So this was a deliberate act. It wasn't one of impulse. It took some real effort to steal this motorcycle and go off with it. So how do you formally plead to the charge in count one, felony theft at this time, Mr. Smith?
Guilty, Your Honor.
Okay, let's talk about what happened. According to the state's charging document, Mr. Smith, this happened on or about August 3 of 2025. Is that when it happened?
I believe so, Your Honor.
And it happened somewhere in Butler County, Kansas. Where was it?
Dearborn Street, or the alleyway behind Dearborn Street
Okay, Dearborn,
in
to the court's
Augusta.
knowledge, is in Augusta, Kansas. Is that where it is?
Yes, sir.
In Butler County.
Yes, sir.
All right. Theft involves a taking, stealing, essentially. So what was taken here?
A motorcycle.
All right. And you did not have the permission of the owner to take it?
No, sir.
Did you take it with the intention of permanently depriving the owner of the benefit of that property?
Yes, Your Honor.
Kansas versus John Robert Smith. It is case number 2025 CR 350. This matter comes before the court at this time for sentencing. The court's docket notes indicating that the defendant appeared before this court on November 5, 2025. At that time, he entered a plea of guilty to count one, felony theft, a level 9 felony. A pre-sentence report was ordered, sentencing set for today. The court has received a completed pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator, who is present on the meeting with us. The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score B, and the court will proceed further accordingly. Ms. Norris, are you aware of any legal reason why sentence should not proceed in this case here this afternoon?
No, Your Honor.
Mr. Favre, are you aware of any such legal reason?
I'm not, Your Honor.
Mr. Smith, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with sentencing at this time?
No, Your Honor.
We'll proceed further then. Counsel, I am aware that there's been a motion for a departure sentence filed in this case. Mr. Favre, you may proceed further on your motion for dispositional and durational departure findings.
Thank you, Your Honor. Your Honor, we are requesting the court make those dispositional departure findings today. Mr. Smith is a young man. He's 24 years of age. I apologize, 25 years of age, my mistake. And he has had a somewhat rough criminal history, but all of that was when he was 19 years of age. And what we're asking the court to consider is that since his rough childhood and the criminal history in the PSI reflects that he has a significant juvenile history, as well as some cases, mostly flee and elutes, that occurred after when he was 19 years of age. Since that time, though, he has had a good record in the community rebuilding his life. We're asking the court to consider that and not to stymie his progress by sending him to the Department of Corrections at this time. There's a couple factors we'd ask the court to consider. First of all, in support of the idea that he's rebuilding his life, we've attached proof of his employment. He does have good employment. He has been working at that job for 15 months now. He makes $19.10 an hour. It's a full-time job. We also sent in late, just recently, a letter from a former worker of his that testifies to his conscientiousness as a worker. We asked the court to consider that as well. Mr. Smith has held this job down, has excelled at this job, has been promoted, and he is being successful in the community with that employment. In addition, he's recently started addressing some of his underlying motivating factors for his criminal history. He's getting himself into mental health treatment. He's starting next week a Bible study group that he is joining with the Men of Recovery Unlimited, and he also has started mending the fences of his family, with which he was estranged for quite a while. His mother is back in his life. She has significant health issues. He is trying to support her. In essence, the overall picture of this is that Mr. Smith has made significant efforts to try to be a successful member in the community and to fix his wayward past. Now, normally, if this was a drug case, and even in this case, he would be screened for Senate bill, and would possibly be discretionarily Senate bill. And he was screened. I contacted Ms. Morgan for Senate Bill Plus. Because he has only level 8 through 10 felonies, he could potentially have been Senate bill eligible as a discretionary measure. However, he's been sober for the last 6 years, and so he scored very low on his alcohol and drug need assessment. And because of his own taking responsibility for his sobriety, it makes him ineligible for the state program that would have normally placed him on probation to be in the community. I think that is a positive in his factor, in his consideration. I mean, and we'd ask the court to consider it as such. Lastly, Judge, he's taken responsibility for this quickly. He entered a guilty plea. It was his first preliminary hearing setting when he did that. He's agreed to take full responsibility for the restitution in this matter. He has, by his own admission, just made a very bad mistake here. He saw the bike. He took the bike. It was a mistake. The bike luckily got returned. There was some damage. He's willing to take responsibility for that damage. The state also has agreed to stand silent because of that. We ask the court to take into consideration the state's agreeing to not directly oppose the departure motion as a factor in considering this departure request. So we are asking the court to depart from the normal presumption, place Mr. Smith on probation with community corrections. In the alternative, if the court is willing to not consider the departure, we'd ask the court consider offering him a durational departure to a lesser amount of time, because ultimately any time he is serving in is going to significantly derail the progress he's already made, Your Honor.
Very well, Mr. Favre. Ms. Norris, did the state wish to make an argument in regards to the departure motion?
No, Your Honor.
Anything further? I will note, Mr. Favre, that the court did receive the Heather Reynolds letter dated 12/30 of 25, which I think was the document that you had referred to earlier in your argument. Is that correct?
That is correct, Your Honor, yes.
Court is aware of it and will consider it. So at this time, the court will ask for formal recommendations from counsel regarding an appropriate sentence, beginning with Amber Norris on behalf of the state of Kansas.
Your Honor, regarding the theft, count 1, would ask the court assign the 13 months, the mitigated sentence in Department of Corrections. Defendant could earn up to 20% good time credit and would be subject to 12 months post-release. The presumption, as noted in the PSI, is prison. Defendant has 1 day of jail time credit. Ask the court assess the cost of the action to the defendant. Court will need to address court-appointed attorney's fees and the bid's application fee as Mr. Favre is appointed. And Your Honor, there is restitution. The state forwarded to court and counsel the victim impact statement that was forwarded to our office. It was not attached to the PSI that I'm aware of. So we did forward that to the court and counsel. It is for $510.81, which basically is the replacement of the ignition switch. We would ask the court order that as restitution to the victim. Otherwise, Your Honor, state has no further recommendations for the court at this time.
Very well. Mr. Favre, your recommendations regarding an appropriate sentence?
Judge, we ask the court to place Mr. Smith on corrections and grant the departure motion. No objection to the standard conditions of probation listed in the PSI. We will note that Mr. Smith we will say again, Mr. Smith is willing to take responsibility for the restitution. Court can inquire of him. That amount is fine. I've already talked to Mr. Smith about that amount, and he does, as I noted, work full-time and is able to and willing to take responsibility for that. We would ask the court to consider whether it wants to consider his attorney's fees given the restitution. He does make $19.10 an hour, so I'm not sure if that's necessary, but the court-appointed attorney's fees in this matter are $1,100, and he does have other court costs and restitution that he'd be required to pay.
Mr. Smith, a restitution amount has been proposed to this court in the amount of $510.81. Are you in agreement that that's a proper amount to assess for you to pay in this case?
Yes, Your Honor.
All right, very well. Do you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court?
I agree to the fines and fees and everything that has been brought to my attention due to the fact that I am working constant throughout the week. Recently, the only days that I had off for the past month and a half was Thursdays. other than that, I'm the sole household income to pay rent, uh, and utilities and other stuff like that. Granted, they're not my actual kids. I do have fur babies and reptiles that we do take care of as well. So it would be a very big impact on my significant other if I do be placed in incarceration.
All right. Anything else, Mr. Smith?
Um, I take full responsibility for my actions, due to the fact that it was a very inappropriate decision of mine to make. I take responsibility for what I did, and I'm very apologetic about it. It has weighed a lot on my shoulders ever since that day. Um, and I will do everything and anything that I can to make amends, and also do what I need to get counseling, therapy, and better myself as an individual and get my thought process back on track.
Very well, Mr. Smith. Court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of felony theft, a severity level 9, non-drug, non-person felony, whereas the defendant has a criminal history score of B, thus placing him in grid box 9B. The court hereby sentences the defendant to a term of 13 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. The court finds that in grid box 9B, Mr. Smith is presumptive prison under Kansas law due to his criminal history. Court has considered the motion for both a durational and a dispositional departure in this case. Court does find that the defendant in this case has accepted responsibility for his actions, that the state does not actively oppose a departure sentence in this case. And in the view of the court, the current crime of conviction, combined with evaluation of this defendant's criminal history, does not merit an initial prison sentence from this court. This court will find substantial and compelling reasons, therefore, to grant a dispositional departure in this case. Court will place this defendant on probation initially for a 12-month term to be supervised by community corrections. Community correction supervision is deemed appropriate because the defendant scored high on his LSCMI, also because this is a departure sentence from a presumptive prison sentence. Further, Mr. Smith, theft is a huge problem in Butler County. And in fact, I think in all counties of our state, your behavior must be deterred. I don't think that you took seriously your actions when you stole this motorcycle and apparently damaged the ignition so that you could steal it. So this was a deliberate act. It wasn't one of impulse. It took some real effort to steal this motorcycle and go off with it. I do understand the statements have been made about your progress, your work situation, your family situation, and the like. But Mr. Smith, you didn't care about any of that when you stole this motorcycle. And you're a guy that's in the B box on the grid. In other words, any felony you commit for the rest of your life, you're going to be presumptive prison. You didn't care. Now, the court has made findings to support a departure sentence, as the court found earlier, Mr. Smith. I don't think you're a correctional facility case at this point. You're not a prison case. You should have an opportunity to be on probation in the community. But the court's going to order you to serve the maximum amount of jail time as a condition of probation that it can order. And that is a maximum of 60 days. You have 1 day of previous credit. So the court's going to order you into custody today to serve 59 more consecutive days in the Butler County Jail as a condition of probation in this case. You need to have some shock here, some disruption of your life, Mr. Smith, to drive home just how close you are to just being incarcerated and locked away in a prison somewhere. And then maybe you'll think twice about stealing someone's motorcycle or doing any other theft or crime in Butler County, Kansas. So the court will order 59 days more. It's actually a 60-day sanction with 1 day jail time credit, so he has to serve 59 more days. I've considered the possibility of work release in this case, Mr. Smith, but I want this to be a disruption of your life to the extent that every single aspect of it has been touched by your criminal behavior. And so the court is going to deny any release privileges. You're going to serve 59 more days starting now. Now, I hope that doesn't cause true hardship for anyone else. But again, this is something you should have thought about. Furthermore, Mr. Smith, you certainly didn't have any guarantees coming into court today that you weren't going to go to prison. In fact, you were presumed to go to prison. So I presume that you've made proper arrangements which took into account that you very well may be going away for a very long time. Did I see you raise your hand, Mr. Smith?
Yes, Your Honor.
For what reason?
I will end up losing my job for doing
You
time.
should have thought about that. I hate to see you lose your job. If you're really that good of a worker, they're going to hold your job for you or they're going to hire you back. And if you do lose that job, that's regrettable, Mr. Smith, but you caused it, no one else. So work release privileges is denied by this court. Court's already dealt with the issues of restitution to a victim and jail time credit pursuant to KSA 223608C. Mr. Smith, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing.
If before he's taken into custody, if we could have a breakout room where I could get address, email address, phone number, and give him Mr. Ketley's name and number.
All right. I think we can accommodate that, Ms. Stanfield. When we recess the case, Mr. Smith, I'm going to ask you to stay in that location and hope the officers are hearing this. I want you to meet with your community corrections officer before you're taken to jail. And she's going to give you some direction about what you need to do when you get out.
Yes, Your Honor.
Oh, I'm sorry.
Okay. Mr. Smith, do you have any questions regarding the court sentencing orders?
No, Your Honor.
All right. I hope you're successful on this probation program. Again, this was a dispositional departure case. If you come back before the court, you very well may be looking at a prison sentence. So don't let that happen. Do everything else that you're supposed to do. Further, I'm going to ask the security officer that once he's done with Ms. Stanfield, if he has a cell phone on him, I would just ask you to consider, and I don't want to interfere with sheriff procedure or security, allow him to make a call to someone, either his employer or a significant other, so that he can report to them what's happened in court. I think that
Yes.
would be a reasonable accommodation to make under these circumstances. But again, I'll leave that to the sound discretion of the security officers. Seeing nothing further, the court will recess this proceeding as the sentencing is concluded. We will leave the Zoom meeting open for allowed conferencing between Ms. Stanfield and the defendant. Everyone else can leave the meeting at this time.
S case hits hard right from the start because this wasn't some careless mistake or heat-of-the-moment crime. It was a calculated move where Mr. Smith deliberately stole a motorcycle, admitted it openly in court, and even confirmed he intended to permanently deprive the owner of it, which instantly set the tone for everything that followed. The court quickly established the facts. The theft happened in Butler County, Kansas, and Smith had zero permission to take the bike. No confusion, no gray area, just a straight-up felony theft. Now, here's where things get interesting. The defense didn't try to deny the crime. Instead, they went all in on damage control, painting Smith as a young man who messed up but has been trying to rebuild his life. They highlighted his steady job, earning $19.10 an hour, working consistently for over a year, trying to reconnect with family, and even taking steps toward mental health support and personal growth. On top of that, they emphasized something rare: he's been sober for 6 years, which ironically made him ineligible for certain rehabilitation programs that could have helped his case more. Basically, the defense was screaming one message: this guy is not the same person he used to be. Don't send him to prison and destroy the progress he's made. Even the prosecution didn't strongly oppose this angle, staying mostly neutral, which gave Smith a real shot at avoiding prison. But the judge wasn't just going to let that slide without a reality check. The court made it crystal clear that this wasn't some impulsive mistake. A theft required effort, planning, and intent, especially since the motorcycle's ignition was damaged to carry out the crime. That detail hit hard because it showed premeditation, not stupidity. And then came the brutal truth bomb. Smith didn't care about his job, his family, or his progress when he committed the crime. The judge basically called him out: if you were building a better life, why risk it all for a stolen bike? That's the contradiction that nearly cost him everything. According to Kansas law, with his criminal history score, Smith was sitting in a presumptive prison category, meaning prison was the expected outcome, not the exception. And yet, this is where the story flips. Despite everything, the judge acknowledged the positive factors: his acceptance of responsibility, early guilty plea, willingness to pay restitution, steady employment, and lack of strong opposition from the state, and made a bold decision. Instead of sending him to prison, the court granted a dispositional departure, placing him on probation. But don't get it twisted, this wasn't mercy without consequences. The judge made sure Smith felt the weight of his actions by slamming him with the maximum allowed jail time as a condition of probation: 60 days, 59 remaining after credit. No work release, no soft landing, no comfort. The judge literally said this needs to be a shock to his life, a disruption so real that it forces him to understand how close he came to losing everything. And when Smith tried to plead about losing his job, the judge shut it down cold. You should have thought about that. That line right there sums up the whole case: actions have consequences, and sympathy only goes so far. The court also ordered restitution of $510.81 for the damage, making it clear that accountability isn't optional. In the end, Smith walked a razor's edge. He avoided prison, but barely. He got one last shot, and the judge made it clear that if he messes up again, there won't be another chance. This case is a perfect example of how the court balances punishment and opportunity. You can get a second chance, but you're going to pay for it first, and you're going to feel it. Smith's future now depends entirely on whether he learns from this shock or wastes the opportunity he barely managed to hold on to. If you want more raw courtroom breakdowns like this, no sugarcoating, just straight reality, then don't scroll away. Hit that like button, smash subscribe, and stay locked in, because the next case might be even crazier, and trust me, you don't want to miss it.